We'll go ahead and get started. I put all of these information sheets in the chat just so that you have them. Not only is it the law updates PDF, but if you look at the chat, we've got the CTA, Corporations Transparency Act stuff, as well as the public roadways stuff in there as well. So you can download those, use them, abuse them. They're great information. It's the written material for today. Okay, so speaking of the law updates, trying to get this chat out of the way. Hold on just a second. You'll notice on this first one here, alteration of condominium units. Well, actually, before I start this, legislature's adjourned. All of these laws that we're going to go over, these updates to the statutes, are going to take effect in mid-September. So before then, you want to make sure that you're up to code. There's a few things in here that management companies are going to need to do for agendas on behalf of their boards. And obviously, a couple of these things, all of these things we're talking about are going to be effective mid-September on. When we get, there are a couple of these that have caused a lot of heartburn that we'll go over. A few of us not so much, and I'll explain why. I'm not so concerned about the collection stuff. But in any event, this is a CMCA class. There was one hang up. We submitted everything on time, but we're still waiting for the approvals to come back. So once we get the approvals, Christy will send out those certificates to you. So if you don't see them right after the class, that's why. We're just waiting for the final approvals from CAI for your CMCA credit. Okay, well, without any further ado, I'll tell you one joke. It's not a stupid law, essentially, but it's just a joke that my son told me this morning that it was hilarious. So here we go. If you haven't heard it, you probably, there's a good reason for it. It's really stupid, but when your 10-year-old says something, everything's hilarious, right? So here's the joke. What do you call 5 toes that's not on your foot? My foot. So stupid. So stupid. Anyways, he said that and I just couldn't help but laugh for like a couple hours. All right, so let's dive into the law updates here. Alteration of condominium units. This only applies to condominiums. It's ARS 33-12-12. What you'll see here is the actual language. As you're reading through this, especially as you download this and look at this on your own, if you see all caps, that's the new language coming in. If you see lower caps, that's the existing language. Okay, so these are the all caps are the actual modified language. Basically, to summarize what this statute's saying, on the left column, I've got the actual language. On the right column, I have a summary. So up until this point, let's say you've got an old condominium unit and you have CC&Rs that prohibit hardwood flooring. Well, a lot of judges lately aren't willing to enforce that kind of a provision when the unit owner can prove that the underlayment is way better than what it would be if it was just carpet. And obviously, these older condominiums, you find this more and more in the older condominiums, because back then the technology wasn't nearly as advanced as it is today. So when you, for people, managers and boards that have questions about, well, our CC&Rs prohibit hardwood flooring, they put hardwood flooring in, it's a violation of CC&Rs that need to enforce it. Well, now we have an actual statute that says you can't enforce it unless. So let's talk about that. The association right here under subsection B on the summary. So this is basically saying that you cannot prohibit a unit owner from making improvements or alterations in their unit, even if the changes might disturb adjacent occupants. What does that mean? It means the sound. So if a downstairs neighbor calls you to complain that the upstairs neighbor is too loud, that's a disturbance, right? But the actual language says right here, if you look over here, an owner's expense any reasonably necessary improved accessories or other adjustments that eliminate or minimize the potential for disturbance. So what does that mean? The unit owner has to pay for and install improvements and materials that eliminate or minimize that disturbance. So if they submit underlayment that is within industry standards, then that's sufficient. Obviously, if they just put hardwood flooring down over the concrete or over the plywood without any kind of soundproof barrier, that's a big problem, right? That's a violation still. But if they take actions to minimize or mitigate that disturbance and it's within industry standards, you're good to go. So I don't really mind too much. I mean, my opinion before the statute even was you don't really enforce hardwood flooring if they can show that there's sufficient underlayment, because judges aren't really excited about that right now. So there you go. If you're a condominium unit, take a look at this. It's going to impact what you can do with hardwood flooring. And talk to us about getting your rules updated to at least allow make your rules specific of what that flooring underlayment and the soundproof barriers look like. Okay, next one. This is the big one. This goes to liens and assessments. Now, under this one, hold on just 1 second. Under this one with liens and assessments. Now, we all know you can't foreclose on fines, right? And that's been the law and statutes for years and years. It was changed years and years ago when an HOA tried to foreclose on an older lady with cancer, from what I understand, for fines of weeds, and the legislature's like, no, you can't do that. We're not going to do that. So they changed the statutes, and I'm okay with that and they kept foreclosability on assessments, because that's the lifeblood of a community association is assessments, obviously. This statute clarifies what lien the association has, and it distinguishes between, and it gets really specific now. You have the assessment lien and all the accompanying charges over here. That's a lien that you can still foreclose on. And you have all of the member expenses over here that are still a personal obligation of the member to pay. And you can actually sue them and garnish them for all that stuff if you want. But over here, but we're going to focus on the lien right now. The lien is assessments. We already know that. And let's actually look at the actual language here. I'm going to open this up a little more, move my chat function out of the way. Common expense lien means the lien for assessments, charges for late payment of assessments, and here's an important point: if authorized by the declaration. So now when you send the collection matter to us, we got to make sure that the CC&Rs, i.e. declaration, has authority to charge late fees for those assessments. And most CC&Rs do. Okay. Including reasonable collection fees and costs incurred or applied by the association. That's what your management company is probably charging for the letters. And if they do a lien fee, all of those things that management's already doing or the board's already doing. And here's the part that freaks a lot of attorneys out. And also reasonable attorney fees and costs, and this is the part, that are incurred with respect to those assessments if the attorney fees are awarded by a court. Okay? It's basically saying that the assessment lien of an association is all the things you already thought of, but when it comes to attorney fees and the attorney costs incurred to collect, that is not part of the lien until a judge awards them. And so it's caused a lot of firms out there to reboot their collections programs, maybe charge more fees for them, maybe charge you, say we can't do the deferred collections, no cost collections, homeowner pays, whatever the term is called. Or if they do, Anyways, there are risks associated from those firms. There a lot of folks, they're all my friends. They're kind of freaking out about it a little bit. My position is we've been collecting this way for about 4 years now, since a case called Bocino. Bocino dealt with almost this exact same thing, but in the enforcement context, with attorney fees incurred in enforcement. So then all the law firms, including me, were like, well, this case doesn't apply to collections. But at that time, I said I can foresee that this is where we're going. So we're going to make internal adjustments now 4 years ago. So when we collect under our deferred collections model, which is just like everything you see where like we don't bill the association. We obviously have hourly collections too, where we bill the association as we go for boards that want to keep more control over their files. But most communities now like us to only bill them once we collect our attorney fees and costs. So we made changes 4 years ago, and nothing about what we're doing except for one thing is changing what we do. We're still offering deferred collections. There's really nothing on your end you're going to see that's different because of this part of the statute. The only change is going to be dealing with payoff demands. So we all know, like title, when a home goes to sell, title sends a payoff demand or a payoff request. You put together the ledger and you send them a payoff of what's owed, et cetera, et cetera. If it's with an attorney in collections, you ask us to send you the payoff letter. On our letter, it will have our attorney fees and costs with our disclaimers on it for them to pay. And we have to recognize under the statute that technically those attorney fees and costs are not part of the lien quite yet, but we think they should be. And if they want to litigate over it, we're more than happy to. So there's two types of payoffs when they're sent. There's either a payoff request when it's in pre-litigation, so there's no foreclosure lawsuit's been filed yet. Well, if they don't pay our attorney fees and costs and they just pay the assessments, et cetera, we don't really have a way to go after them now for our attorney fees unless the board wants to on an hourly basis. So in that scenario, we just bill our attorney fees and costs, and it's probably gonna have to be eaten. There's just no way around it. That is the bad news with this statute. And all of us attorneys agree on that point, that there's just, if you already paid off the assessment amount, now what can you foreclose on if you file a foreclosure action later on and you're only requesting attorney fees and costs? I don't think any judge in the world is going to allow foreclosure then at that point. Now, they may allow a judgment against them for attorney fees and costs that are awarded at some point, but I don't see that going to foreclosure. So the bottom line is, if somebody's in our office for collections and it's pre-litigation, meaning we haven't filed a lawsuit yet, and they don't pay the attorney fees and costs in a closing, we're going to probably close that file and we're going to bill our attorney fees and costs. Now, if it is in litigation, let's say we've already filed for foreclosure, we're going to be sending the payoff demand, and in there it's going to say we're not going to release the lis pendens of the foreclosure until our attorney fees and costs are paid. When we file for foreclosure, we've also record what's called a lis pendens. A lis pendens is a notification to the whole world that it's subject to a foreclosure lawsuit. And in a foreclosure lawsuit now, if they don't pay the fees and costs, we can just ask the judge, if they send a check for payment of whatever, we then just ask the judge, okay, we've gotten the assessment payments, et cetera. Court, you need to now award our attorney fees and costs that are part of this lien. I think every title company in the world would be very, very dumb to go ahead and allow a closing with a lis pendens that's not released, because that is now on the title company. So they're gonna, I don't see a problem in a litigation context at all for anyone. And basically, if like I said, they should be paying the attorney fees and costs, but even if they don't, and even if they close on the property with a pending litigation, once we get the award of our attorney fees and costs as part of the lien, then the new owner has to basically pay it, and they've got a claim against title on title insurance, because now we've got the awarded attorney fees and costs. Okay, so at least for now, that's how we're working this. It may change based on future case law, based on future statutory language, but at least right now, the only change to deferred collections is going to be what happens in a payoff demand when it's before litigation. I forgot to mention too, if you have any questions as we're going through this, just put it in the chat. That's fine. We can do that. All of this language you'll see is just goes to all of that, is what the common expense lien is, the lien versus the what the member owes as a member expense. Now, so we have the lien on that column, like I said at the beginning, we have the member expenses that they owe on this column. On this column, that includes fines, anything related to the fines, late fees for fines, your fees, blah, 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 blah. And nothing really changes on that column from what you're already used to. Okay, next one. This one is the still the summary, basically everything I just said. Now, transfer fees. This one applies to both condominiums and planned communities. There is this term of art that sometimes people get confused with. So let's make sure we know what we're talking about as far as definitions go. There are disclosure fees that are the $400 that management companies charge to provide all the stuff to close all the governing documents. You know what I'm talking about, that $400 fee that the management company charges and receives at closing. Okay. Transfer fees, some people call them transfer fees. They're not technically transfer fees under the legal definitions. Transfer fees are more fees that are authorized by the CC&Rs that say when you close on the property, the association, not the management company, gets a transfer fee of X amount. And usually they're set by the board. Sometimes they're set by the CC&Rs, but I think the industry standard is maybe two months worth of assessments or more. They can be percentages of annual square footage. They can be whatever the board deems is a reasonable amount, typically. And that does not go to the managed company. It's not part of the $400 cap. It is something that goes to your operating account. There are other fees too, called reserve contribution fees, that maybe they have to pay if they're authorized by the CC&Rs, that go to your reserve account. Maybe there's capital contribution fees that you might see in some newer CC&Rs, which go to the association. None of those are part of the $400 cap the management company gets. Well, what this statute says is it makes it very clear that if I own the property, let's say the deed is in Clinton Amy Goodman's name, okay? And I decide to transfer or sell or convey that property now to the Goodman Family Trust or to another estate planning tool that I've got. Something that's basically still stays within my power. You don't charge those transfer fees in that scenario. Okay. These are, you can charge the transfer fees and those other fees in the context of sales between me and a third party. But if it still stays within my wheelhouse and it's just a conveyance between me and my my entities or my estate planning tools, then you can't charge that transfer fee. Okay. All right. Unlawful CC&R provisions. This is an interesting one. Basically, we've got this Callaway case. If you haven't heard about the Callaway case, really briefly, it basically says that, and it's an Arizona Supreme Court decision that held that they don't care what the general amendment provision is at the end of the CC&Rs. In order for an amendment to be valid, it must be reasonable and foreseeable. And that's caused all sorts of craziness and confusion among the judges and a bunch of things. And by and large, the Court of Appeals now are upholding Callaway. But we meaning the HOA world, are waiting on the Supreme Court to rule on Callaway again, whether they're going to pick it back up and help us give us more clarification on Callaway or not. There's a request the Supreme Court do that. So we're waiting on that one. But meanwhile, the legislature adopted this. It said that the board, not the members, but the board can amend unlawful CC&R provisions. Okay. What does that even mean? What is unlawful? What that means is it means just like what this is saying. Essentially, I hate to say it this way, but there are racist provisions out there occasionally. There are provisions in CC&Rs that could discriminate on the basis of race, religion, sexual orientation, familial status. If you run across the CC&R provision that violates the law, federal or state, the board can amend that unlawful provision. Okay? So obviously, before you were to do that, don't just make your own decision on that. You're going to want to have the attorney for the association give you a thumbs up and help you do that amendment for the board to sign and record. But this gives the board authority to remove from the CC&Rs via amendment unlawful provisions. I actually like that one. Okay. Declarant control in planned communities. This only applies to planned communities. 1820, not condominiums. How many of you have ever managed a community that seems to have declarant control for forever? Never, never, never ends. And it's an interesting concept, but it happens. Well, I don't know if this really changes too much, but ultimately this requires that declarants in the CC&Rs provide the method of terminating. In other words, terminating declarant control and conveying it back over to the homeowners for the homeowners to run. It allows for an automatic termination of declarant control, no matter what the documents say. But it's interesting because it says, the statute now says, is that declarant control terminates automatically when the declarant is sold the second to the last lot to the third party. But it's up to the declarant when the declarant sells the second to the last lot. So I don't know how much more that really helps, but it provides automatic termination of declarant control when that happens. It also imposes certain maintenance obligations on the association post termination, because declarants, developers, I think the ones running and wanting this in here were concerned about their reputation. They wanted to make sure that if it's pick the name of the builder, if it's that type of a community 20 years from now, it's still, it's still a beautiful community and it doesn't detract from the reputation of that brand. So basically, if you look over here on the right column, after termination of declarant control, you must provide at least the same level of maintenance to the common areas as the declarant did and not impede on the declarant's ability to develop, construct, and sell its lots. Sometimes the declarant developer, like I said, sometimes the documents already provide for transition to the homeowners, even when the declarant owns a batch of lots still. So the statute's just saying, HOA homeowner control board, you can't impact or adversely impact what the developer declarant's doing to sell those lots and develop them. But you already probably have that language in your CC&Rs anyways, because the developer put them there. And lastly, ensuring the declarant has access to and use of the common areas in the same manner as all members. Apparently, some homeowner control boards wouldn't allow the declarant to access the common areas like other homeowners. And so now we have a statute that deals with that. So that's this one. If you have questions about this one, it doesn't pop up too often because I think most of you are portfolio managers. But if you have a newer community that you need advice on and you're worried about some sort of conflict with the declarant, check in with us. We'll make sure that you're compliant with this statute. Okay. Let's go to the next one. Why isn't this letting me roll down to the next one? There we go. Last one, at least on this worksheet, and then we're going to go to public roadways and CTA real quick, is we got yet again another amendment to the flag statute. This one's easy. This one doesn't add additional flags, etc., but allows in the association's rules to regulate the location and size of flagpoles, or I'm sorry, that's the prior language, the all caps. You can limit now the member from installing not more than 2 wall-mounted flagpole holders. So if they're going to put 10 flagpole holders on their building and there's 10 US flags, your rules can prohibit that. And they can only have up to 2 if your rules provide that. Now, if you don't have any rules, then that's another question entirely, right? But if you have rules that you can, those rules can by statute limit the member to 2 wall-mounted flagpole holders. Okay. Any questions? Let's take a look. I don't see anything in chat. So I'm going to move on to the public roadway stuff. Nothing was done this session on the public roadway stuff. Statute's still the same. What is the statute? The statute says that the homeowners association, and this only applies to your communities that have public roads. It does not apply to those with private roads or one-way streets. Only public two-way roads. Okay. The board has to have a meeting with the membership. It's not a board meeting, it's a member meeting, but it needs to be called by the board or a special meeting of the members by June 30th of 2025 to vote on whether to keep the enforcement provisions in play with the CC&Rs on public roadways or to not. And if it fails, it requires simple majority of quorum. This info sheet here explains exactly what it is. And it also explains you need simple majority of a quorum of the members to vote to keep it. If the members turn it, and the quorum is whatever your bylaws and articles say. And like I said, it's just simple majority of quorum. If the association decides to retain that authority, you have to record with the recorder's office, the county recorder's office, a notice of enforcement, public roadway enforcement, saying that you're retaining it. If you don't record that, if you don't have the vote, the association loses the ability to enforce. Remember, this is really only for communities with CC&Rs that were recorded before January 1st of 2015. For all those communities with CC&Rs recorded after that, you already don't have authority over the public roadways. It's already a city responsibility anyways. So, do I think this is going to change? Maybe next session. I don't know. What's my advice on this one on timing? I think that you should start letting the members know. And I think that you could either do it during your annual meeting before June 30th, 2025, or at a separate time. I think that if you've got a community with serious public roadway concerns and you want maximum participation, the best time to do this vote would probably be between October and November, sometime after Halloween, but before Thanksgiving, when everybody's kind of in town. You've got all the winter visitors here, or after the holidays, sometime between March and May before they start departing. Maybe even just before spring break, because most people are still around between February and spring break. So maybe that's another good time for vote. Can you allow for electronic voting? Yes, you absolutely can. Nothing about the voting process changes. Am I seriously surprised nothing changed about the statute? Yes, because the cities were up in arms about it because of all the extra liability and costs it's going to put on their backs. So maybe they'll change it again next session. Some boards are like, well, if they change it again and we do the vote now, what does that mean? That's a good question. That's why my personal opinion is you wait to do the vote until 2025 between February and March. We're obviously probably still going to be in the legislative session for that next session, but I think at least by then we'll know if there's even movement on this statute or if it's a dead issue. So if you want to vote before the end of this year, go for it. If you don't, you want to wait, you can still wait. Okay. If there aren't any questions on this, I think that completes today. try to keep this no more than 45 minutes or a half an hour to 45 minutes. I want it quick and easy because I know all of you guys are busy. But if you, this is recorded, it will be posted online. Like I said, the chat has all of these PDFs that we've attached and gone over today for your viewing pleasure. You can kick them off to your other managers, board members. It does not matter. It's yours. Do what you will with it. And if you have specific questions for your communities, feel free to reach out to me. I'd be happy to share any of
I'm
those.
I'm not sure you're seeing, there are a few questions in the chat. Is any of that coming through where you're at?
No, I can't see them. Can you go ahead and read those questions for me?
Yeah, I believe this is on the transfer fees back towards the beginning. Pam Rogers asked, can you charge an admin fee?
Okay, so on the transfer fees, that's specific to what is authorized in the CC&Rs. The admin fees are, I think if you're talking about admin fees for like putting together the disclosure packets you have to send off the title, that's all covered under that $400 fee cap for the management company. If you're talking about admin fees and other fees at closing that are owed to go to the association, it has to be in the CC&Rs. And the three main ones are they're actually titled transfer fees, capital reserve contribution fee, and contribution fees. Reserve contribution fees, et cetera, et cetera. So they go by many, many different names, but the main point here is if you're going to be charging an extra fee at closing, that goes to the association, um, it has to be in the CC&Rs. If for that specific question, shoot me a direct email if you can explain to me what exactly is composed of that admin fee, and I might give you a different answer because it could be fact dependent, but I'd say
Um,
normally,
Sorry, she's further clarified admin fees in regards to changing your deed to a trust.
oh, got it. Okay. Let's go back to the statute real quick. The actual language shall not charge a fee authorized under subsection C of this section for any conveyance between parties prescribed. I don't think that fee can be part of a transfer fee, the admin fee. Um, I think that this statute is only referencing the transfer fees and other fees like the 2 months of assessments or whatever it's gonna be. It doesn't necessarily address admin fees, but I think you're walking a gray line there that may violate the law because the other provisions that this is quoting to say that if you're going to charge any kind of fee at closing for transferring or conveyance of the property, it has to be authorized by the CC&Rs. So if the CC&Rs authorize a specific admin fee, then yeah, maybe. But if you're only talking about stuff for the management company you're charging, generally that's just a fee that's in your contract with the board. And I don't see that as being something you can charge at closing.
Okay. From Barbara Weiss, what does a board do when we are unable to get quorum? I believe that came through when we were talking about the parking.
Okay, great. So if you don't hit quorum, the vote fails. Simple as that.
Uh, Next question from Barbara. To confirm, boards must comply with CTA. Yeah.
It's not a may, it is a shall. And again, if a board member does not comply with this, um, I I would not be refiling a Boyer with that board member's name. And and the only way that I'm gonna be able to file the Boyer is if I am true and accurate in my filing with the court. So if I say there's two board members, there's two board members. If that third isn't doing anything, they're off the board, they're disqualified. And by the way, one thing that I didn't mention in the CTA that you probably heard is anytime there's a change in the board from the initial filing, you have 30 days to amend the report with that Boyer. If you don't, you're in violation and subject to penalties. So it's a pretty strict and stringent process.
The next question was, can you share what the feds sent to confirm that HOAs must comply? This is all on CTA.
It was a CAI bulletin thing that came out because a bunch of us CCALs were down at DC trying to deal with them last year, didn't get anywhere. By the way, on that note, CAI, CCALs, we all filed a amicus brief with the circuit courts supporting the rulings that this is unconstitutional. And I think it was a great amicus. I didn't write it, but there was an amicus committee of CCALs at CIA that did it. CAI, sorry. The Central Intelligence Agency. I don't think they're involved in this one. But anyways, it was a great brief. Now, whether the circuit courts, whether the appeals courts really push it forward, great. If they don't, they don't. But that was a bulletin that CAI got that clarified it for all of us. So out to Kate Combs if you want that.
Claudia Overthier, what is the cost that our office charges for the filing?
My office? Yeah, so it depends. If I'm doing this on bulk for management companies, it's a negotiated price. But if you want to know the price of what we charge, it's right on there. Let me go back to it here. Okay, these are the prices for the public roadway stuff. Flat fees for notice and ballot, flat fee for the town hall meeting, if they want me there for a town hall meeting, and flat fee for an executive meeting. But for the CTA, our price is on the second page. There's our pricing for one-offs for boards. But like I said, this is negotiated with, I've had several management company executives reach out to me wanting me to do it for their entire company on a bulk rate. And I'm happy to talk to decision makers on that issue.
Last one on the parking. Paula Bellina wants to know what kind of quorum are we talking about for the parking?
So what your bylaws, your articles, your CC&Rs provide.
If anybody had questions that weren't already answered, go ahead and send those to marketing@goodlaw.legal. I'll drop that in the chat as well. And I'll make sure that they get presented to Clint to respond for you.
Thank you, Christy. All righty. Well, this has been fantastic. I wish that we didn't have to do these law updates. It'd be nice if we could say nothing's changed this year. But man, it seems like every year things are just changing like crazy, evolving. I think I'll end and conclude with when I first got into the HOA world back in 2006, there's this legal pendulum, and maybe some of you have heard me define this, but on this side it's HOA, on this side it's homeowner. And the legal pendulum always is aiming to be right here in the middle. And when I got into the practice, it was way, way over here for HOAs. And we started to see cases becoming more and more homeowner favorable about a decade ago. Not a lot. So when I first started practicing, the pendulum was over here, HOA favorable. Over the last 5 years ago, we started to see more and more homeowner cases because they were trying, the courts were, and the legislature was trying to get the pendulum back in the middle. But what happens, the pendulum really never is in the middle. And if it is, it's only there for a very brief period of time. We're seeing more and more it swing way over here. So for the next 5 to 10 years, you're going to see, this is a constant cyclical kind of thing. It's going to be over here for a while. And then eventually it'll come back. And we'll start to see more over here because that's just how the courts work. That's how the law works. And that's pretty much how it's going to be for a little while. So just put the seatbelts on and enjoy the ride. That's what I was saying. All right. Well, that's great. I don't have anything else. I thank you for your attendance and appreciate the time. Everyone have a great day today. Okay.